Clinical Established Act to provide for the registration and regulation of clinical establishments in the country and for matters connected therewith or incidental thereto. Whereas, it is considered expedient to provide for the registration and regulation of clinical establishments with a view to prescribe minimum standards of facilities and services which may be provided by them, so that mandate of Article 47 of the Constitution for improvement in public health may be achieved. And whereas, Parliament has no power to make laws for the states with respect to any of the matters aforesaid except as provided in Articles 249 and 250 of the Constitution. And whereas, in pursuance of Clause 1 of Article 252 of the Constitution, resolutions have been passed by all the houses of the legislatures of the states of Arunachal Pradesh, Himachal Pradesh, Mizoram and Sikkim to the effect that the matters aforesaid should be regulated in those states by Parliament by law, be it enacted by Parliament in the 61st year of the Republic of India as follows. Chapter 1. Preliminary. 1. Short title, Application and Commencement. 1. This Act may be called the Clinical Establishments, Registration and Regulation, Act, 2010. 2. It applies, in the first instance, to the whole of the states of Arunachal Pradesh, Himachal Pradesh, Mizoram and Sikkim and the Union Territories, and it shall apply to such other state which adopts this Act by resolution passed in that behalf under Clause 1 of Article 252 of the Constitution. 3. It shall come into force at once in the states of Arunachal Pradesh, Himachal Pradesh, Mizoram, and Sikkim and the Union Territories, on such date as the central government may, by notification, appoint, and in any other state which adopts this Act under Clause 1 of Article 252 of the Constitution, on the date of such adoption, and any reference in this Act to the commencement of this Act shall, in relation to any state or union territory, mean the date on which this Act comes into force in such state or union territory, provided that different dates may be appointed for different categories of clinical establishments and for different recognized systems of medicine. 2. Definitions in this Act, unless the context otherwise requires. A. Authority means the district registering authority set up under Section 10. B. Certificate means certificate of registration issued under Section 30. C. Clinical establishment means I. A hospital, maternity home, nursing home, dispensary, clinic, sanatorium or an institution, by whatever name called, that offers services, facilities requiring diagnosis, treatment or care for illness, injury, deformity, abnormality or pregnancy in any recognized system of medicine, established and administered or maintained by any person or body of persons, whether incorporated or not, or 2. A place established as an independent entity or part of an establishment referred to in Subclause I, in connection with the diagnosis or treatment of diseases where pathological, bacteriological, genetic, radiological, chemical, biological investigations or other diagnostic or investigative services with the aid of laboratory or other medical equipment are usually carried on, established and administered or maintained by any person or body of persons, whether incorporated or not, and shall include a clinical establishment owned, controlled or managed by A. the government or a department of the government, B. a trust, whether public or private, C. a corporation, including a society, registered under a central, provincial or state act, whether or not owned by the government, D. a local authority, and E. a single doctor, but does not include the clinical establishments owned, controlled or managed by the armed forces. Explanation. For the purpose of this clause, armed forces means the forces constituted under the Army Act 1950, 46 of 1950, the Air Force Act 1950, 45 of 1950, and the Navy Act, 1957, 62 of 1957, d. Emergency medical condition means a medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, of such a nature that the absence of immediate medical attention could reasonably be expected to result in I. Placing the health of the individual or, with respect to a pregnant woman, the health of the woman or her unborn child, in serious jeopardy, or 2. Serious impairment to bodily functions, or 3. Serious dysfunction of any organ or part of a body. E. National Council means the National Council for Clinical Establishments established under Section 3. F. Notification means a notification published in the Official Gazette. G. Prescribed means prescribed by rules made under this Act by the central government or, as the case may be, the state government. H. Recognized system of medicine means allopathy, yoga, naturopathy, Ayurveda, homeopathy, Siddha and Unani system of medicines or any other system of medicine as may be recognized by the central government. I. Register means the register maintained by the authority, state government and the central government under sections 37, 38 and 39 respectively of this Act containing the number of clinical establishments registered. J. Registration means to register under section 11 and the expression registration or registered shall be construed accordingly. K. Rules means rules made under this Act. L. Schedule means the schedule appended to this Act. M. Standards means the conditions that the central government may prescribe under Section 12 for the registration of clinical establishments. N. State government in relation to a union territory means the administrator thereof, appointed under Article 239 of the Constitution, and O. To stabilize, with its grammatical variations and cognate expressions, means, with respect to an emergency medical condition specified in Clause D, to provide such medical treatment of the condition as may be necessary to assure, within reasonable medical probability, that no material deterioration of the condition is likely to result from or occur during the transfer of the individual from a clinical establishment